Hey there, cats and kits. Captain Zorikh here, known to normal people as Zorikh Lequidre, I guess. And here's a little update about what's going on with 182 Graham Avenue. Okay, so, as you may recall, when the COVID hit, then all the courts were shut down, and we were in court with these HP cases and illegal lockout cases against Antonio Cook, the building manager, Efren Jarena, the landlord, and so forth. But all that got adjourned until they were scheduled for March 19th, but everything got shut down on the 16th. So the cases were adjourned, and then got more adjourned and more adjourned, and in late September, the illegal lockout case got revived. The new judge in the illegal lockout circuit had found our papers under a stack of papers and said, well, let's get this taken care of. And as you recall, those of you who've been following these adventures, the respondents to my illegal lockout case, that is, the landlord, the building manager, their lawyers, had put forth a motion to dismiss the case because I was not illegally locked out. I wasn't supposed to be in the room because of the order to repair / vacate order. Now, our case is that they should have repaired it by now, and any delay is an illegal lockout. And me not having access because Antonio Cook is holding the keys, and he has proven himself to be a danger to my property and to civility and to myself, really. So I don't feel safe with him in my presence, or him in the presence of my stuff in or out of my room. So I was essentially locked out there. Well, we went to court, and if you scroll back to the earlier days in this month, then you can see the report that I gave live after I came out. Also, you can see it on my 182 Saga YouTube channel. Me talking live on Facebook about what happened. Now, the HP case was finally rescheduled. At first it was rescheduled, but Judge Weisberg, who ironically had been the illegal lockout judge before, but the way they cycle things around, now he's the judge in our HP case. It got scheduled for the 24th of September, but then it got adjourned with no scheduled date. Our lawyer, Gerald Crepel, sent a letter insisting we got to have this because these people are still out of the house. There's still me, there's still Clemens, there's still Orta, still out of the house, and there's still a person in there who is being harassed to the degree of, post-traumatic stress. She's got all kinds of medical issues, and the stress isn't helping. So, cut to the chase. I hold in my hand a printout of the actual decision, and I want to have this read out here on Facebook, and then it's going to go on YouTube so that everybody knows the decision of the judge, Judge Wang, in the illegal lockout case on the motion to dismiss the illegal lockout case. Because as long as the illegal lockout case was adjourned, like it had been, to coincide, to reconvene on the day of the HP case, so that the illegal lockout case could use guidance from the HP case, that meant that a court order protecting my stuff in my room and preventing them from renting the room to anybody else would be in effect. But if it's dismissed, then that court order is no longer in effect. Well, here's what Judge Wang said. It's 6 pages, so bear with me, get your popcorn. Recitation pursuant to CPLR number 2219A of the papers considered in the review of the petitioner's motion to restore, that is, to restore possession of the room to me, and respondent's motion to dismiss. Let's see, order to show cause and affidavit annexed, notice to motion to dismiss and exhibits, affirmation in opposition to motion to dismiss, affidavit, and reply affirmation. In this illegal lockout proceeding, petitioner Zorikh Lequidre, now this is Judge Wang talking here, moves by order to show cause to restore this matter to the calendar, and respondent Port Rich Company, Inc., Port Rich, moves to dismiss the proceeding. Both motions are consolidated in the decision and order. Sorry, restore wasn't to restore it to possession, but I wanted to restore it to calendar so that we could get possession. The verb to restore refers to restore the case to the calendar. And also I wanted the judge to take a look at that video of Hernan Cook going into my room and smashing my stuff. That video's on YouTube. Look for Hernan Cook destroys my stuff. All right. Or is it trashes my room? It's on youtube.com/Captain Zorikh. Anywho, back to the judge's words. Background. The following facts are undisputed. He gets a few of them a little wrong. I'll amend them when we get to that point. Port Rich has been the owner of the subject building at 182 Graham Avenue in Brooklyn since 1966. It appears that the building is either a legal 3 or 4 family home with a storefront. It is alleged that prior to Port Rich's purchase of the subject building, the building was illegally subdivided into approximately 10 separate SRO units, actually 15. But when DHCR investigated, they could only identify 10 of those rooms. Lequidre has been one of the occupants of these SROs, specifically Unit 2D, since 1993. Actually, I was in 2A when I moved in 1993, before Port Rich bought the building. I moved to 2D when Port Rich bought the building because the occupant of 2D moved out at that time, and 2D was bigger than 2A. Anyway, it is undisputed that, following an administrative proceeding commenced in 2017 and a petition for administrative review in 2018, DHCR, Department of Housing and Community Renewal, determined that the SRO units in the subject building were subject to rent stabilization, because the building was built before 1974 and we had all been in there for more than 30 days. Although Lequidre's unit was conferred a rent-regulated status, on November 22, 2019, the New York Department of Housing Preservation and Development, HPD, found that a lack of a second means of egress to his unit was, quote, dangerous to life and detrimental to the health and safety of the occupants and others, and is unfit for human habitation, end quote. In turn, HPD issued a vacate order. Now, a vacate order means you who live there get out of the way so the people responsible can fix the place, and then you move in. Well, the landlord and building manager seem to forget the second part out of that and have been trying to parlay that into a de facto eviction, which is what this whole court thing is about, to try to get them to do what they're frickin' supposed to do. Anyway, back to Judge Wang. On December 13th, 2018, Lequidre commenced the instant illegal lockout proceeding by order to show cause seeking to be restored to his unit. Namely, Lequidre asserts in his pro se verified petition, that means doing it without a lawyer, that Port Rich unlawfully deprived him of possession of the subject premises on November 22nd, 2019, the same date that HPD issued its vacate order, and that petitioner continues to keep him from possession. Notably, it is undisputed that Lequidre subsequently filed an HP proceeding and that the vacate order has not been lifted. It bears noting that, upon signing Lequidre's order to show cause in lieu of petition, the court, Judge Weisberg, also issued the following relief. Quote, pending the hearing of this proceeding and entry of a judgment thereon, the respondents and the respondent's attorneys or agents is/are 1. Stayed from reletting the subject premises. 2. Stayed from removing any of the contents of the premises. Also, they were supposed to give me access at reasonable hours for me to be allowed to remove it myself. Despite the stay on removal of belongings, there is a video recording of an individual by the name of, quote, Antonio Hernan Cook, unquote, entering Lequidre's unit with 2 other individuals. In the recording, which was obtained through the use of a hidden camera, Mr. Cook appears initially to survey the premises. He then rifles through certain items in the unit. Then, suddenly, Cook appears to intentionally smash certain items allegedly belonging to Lequidre, including an electronic keyboard, mirror, and a box of screws. Actually, it was a coffee can full of soda can pull tabs that I'd been intending to use as a craft project, but details. He did empty this can, which was a can of tiger's milk from when I was a child, and fling it across the room. You can see this video. Antonio Cooks trashes my room. It's on youtube.com/Captain Zorikh. Anywho, where is it? Yeah. With his hand covered with a cloth, actually with a plastic bag, Cook then proceeds to throw certain of these items across the room. He throws the keyboard, he throws a couple of boxes. Lequidre alleges that Cook is an agent of Port Rich. Indeed, Port Rich's answer contains a verification by Cook, who identifies himself as a, quote, representative of the managing agent, unquote. At oral argument, Port Rich's attorney did not dispute that this incident had occurred, but did dispute the characterization of Cook's conduct. Judge Wang doesn't say what the characterization is. I'll tell you what he said it was. I wasn't sure if it was Ron Hariri or Charlie Balvin, who are both attorneys for the respondents, said that Mr. Cook affirmed that when he picked up the keyboard, he found that it was covered with roaches and he dropped it. Really, dude? Okay. Back to Judge Wang. On January 22nd, 2020, Lequidre filed the instant pro se order to show cause, although the pre-printed form states that the relief sought is to restore, quote, restore to the calendar, unquote, this proceeding. That's what it says on the pre-printed form. The statements in Lequidre's supporting affidavit clearly evince an intent to address the incident captured on video, namely, Lequidre avers that, quote, I have video of the respondent destroying property in my room, unquote, that, quote, this is a pattern of behavior that places myself and my possessions in danger, unquote, and that, quote, the respondent has shown disregard for the court order, the rule of law, and any sense of decency or honor or courtesy or honesty, unquote. Lequidre's order to show cause was adjourned to February 18, 2020. In the interim, Lequidre retained counsel. The motion was adjourned again to March 19, 2020. I'll tell you what happened on February 18th. I showed up. They sent, the respondent sent an attorney. The court attorney for Judge Weisberg said, you two go out in the hallway and settle this. I showed the attorney the video. She was aghast. Called her boss, Ron Hariri. Ron got on the phone with me, buttered me up like a piece of breakfast toast, and I said, we can settle this. I'm sure we can, amicably. And I said, fire Antonio Cook and I'll be at the bargaining table tomorrow. He said, how about if I be the go-between between you and Antonio Cook? And I'm like, fine. And so the case was adjourned to correspond again with the HP case, status quo, and I really wasn't happy with that. I fought tooth and nail, but that court attorney just wasn't going to let it go. Anyway, so that's what happened on February 18th. And so, as Judge Wang says, the motion was adjourned again to March 19th. By March 17th, 2020, both the executive and judicial branches... Oh yeah, I did not have representation on February 18th. Anyway, by March 17th, both the executive and judicial branches had temporarily shut down the court system. The trial date on the petition is scheduled for September 3rd, 2020. Continuing. Port Rich now moves to obviate a trial by filing the instant motion to dismiss, albeit at the 11th hour. On its motion, Port Rich argues that dismissal is warranted as a matter of law based on documentary evidence, that is, HPD's vacate order of November 22, 2019. Specifically, Port Rich contends that it would be futile to restore Lequidre to possession given the vacate order. Lequidre opposes the motion, countering that dismissal is not warranted in view of the history of illegality under petitioner's ownership of the subject building. Even though this court cannot provide such remedy in an illegal lockout proceeding, Lequidre asserts all that the court need do is to order Port Rich to install a second means of egress. Lequidre, at oral argument, also admitted that this proceeding serves essentially as a stopgap until his HP proceeding is adjudicated and ostensibly the vacate order is lifted. That's right. To put a more finer point that I was trying to get across was, give me the key to the room. These guys have shown disregard for the law. They've shown that they're willing to destroy my stuff. They have no intention of following the order, the order to repair part of the vacate order. I, at the very least, will not destroy my own stuff. So give me the key, then I'll be able to remove it at my pace when I need to, and I promise that I will not violate the vacate order by sleeping there or living there. They've already violated all kinds of things. But here's what that's what I tried to get across. Here's what Judge Wang said. Discussion. Generally, on a motion to dismiss pursuant to CPLR 3211, the pleading is to be afforded a liberal construction. The facts alleged in the complaint are accepted as true, and petitioner is accorded the benefit of every possible favorable inference. See Leon versus Martinez, 84 NY 2D 83 87-88, 1994. Within this context, quote, a motion pursuant to CPLR 3211A1 to dismiss a complaint on the ground that defense is founded on documentary evidence may be appropriately granted where the documentary evidence utterly refutes the plaintiff's allegations, conclusively establishing a defense as a matter of law. Jiaping Wang versus Diamond Hill Realty, LLC, 116 AD 3D 767 767 2D Department 2014. Section 71310 of the Real Property Actions and Proceedings Law, RPAPL, provides that, should have brought some water here, quote, a special proceeding may be maintained under this article after a 10-day notice to quit has been served upon the respondent in the manner prescribed in Section 735 upon the following grounds. The person in possession has entered the property or remains in possession by force or unlawful means, and he or his predecessor in interest was not in quiet possession for 3 years before the time of the forcible or unlawful entry or detainer, and the petitioner was peaceably in actual possession at the time of the forcible or unlawful entry, or in constructive possession at the time of the forcible or unlawful detainer, no notice to quit shall be required in order to maintain a proceeding under this subdivision. That's a lot of words to unpack there, but let's hear how Judge Wang unpacks it. A petitioner is therefore entitled to relief, that's me, the petitioner, under the above section if he can prove that 1. The respondent entered the premises by force or unlawful means. 2. Respondent or respondent's predecessor in interest was not in quiet possession for 3 years before entering the premises. And 3. That petitioner was peaceably either in actual or constructive possession when the unlawful entry occurred. That's a pretty key part there. Watch this. Here, the vacate order is undisputed documentary evidence that utterly refutes the first element of petitioner's illegal lockout cause of action. Specifically, that respondent entered the premises by force or unlawful means. If there's a vacate order, then the respondent can enter the premises because they're in possession of it, even though they're not doing what they're supposed to be doing when they're in possession of it. Moreover, the remedy that petitioner proposes in the form of a directive to respondent to correct the violation that gave rise to the vacate order, fix the damn thing so I can move back in, is unavailable in this type of the proceeding. That's what the HP case is for, to give that order, not what an illegal lockout is for. Rather, the appropriate forum to seek redress on that issue is an HP proceeding, one that the petitioner has already commenced. That's me. And the remedy for Port Rich's apparent destruction of petitioner's belongings is available in the form of a proceeding brought under RPAPL SS 853, for which treble damages may be awarded. I'm Facebook Live. I did get the laundry. This is live radio, folks. I folded it up. I put it on the shelves. Okay, where were we? For which treble damages may be awarded. Dismissal of the petition is warranted here because possession, not damages, is the sine qua non of this proceeding. In other words, I got to take my case somewhere else. Now here's his final paragraph. Finally, it bears mentioning that in issuing a dismissal order, this court does not pass on the possessory rights vis-a-vis the parties. If the vacate order is lifted, or if Port Rich leases the premises to another, Lequidre may indeed have a meritorious petition for illegal lockout. Nor does this court countenance the conduct of Port Rich's agent in apparently entering and damaging items in the subject premises, for which an order of criminal contempt may be sought. Nevertheless, the motion to dismiss is granted because the HPD vacate order bars recovery on this year-old illegal lockout petition. Not quite a year, but close enough, I guess. In view of the above, Lequidre's motion, quote, to restore, unquote, is denied as moot. This constitutes the decision and order of this court. Dated September 2nd, 2020, entered by the Honorable Judge Wang, Judge, Housing Court. So, as a matter of law, the court order that the Judge Weisberg signed, excuse me, adorable moment coming up. All right, everybody, say hello to Captain Chewy. Wait. There's Captain Chewy now messing with all my legal papers. You're killing me here, dog. You're killing me.
I think your viewership just went up.
Oh, jeez. Oh, jeez. Chewy, I'm getting to the important part of the matter here. No, it's okay. We love this guy. All right, where were we? All right, so where were we? Yeah. So, the illegal lockout case is no longer a case. It's been dismissed. However, the judge was not happy with what they did, so I can seek an order of contempt and talk to my lawyer about that. I can go file the appropriate RPAPL proceeding. Another lawyer took a look at that video and said, you should have the police arrest him. And, well, we've been through that game already. The police decide not to arrest him, so we go to these people, then those people. They send him to the district attorney. The district attorney says, nah. We look for an order of protection. He can't get an order of protection without an arrest. He's not going to arrest him because it's such a minor thing. And then there was the whole COVID, and then there were all the demonstrations and the riots and everything else. So we went into community affairs just last week, and they said, oh, well, then go to these other people. And, it's the whole big fucking ring around the rosies all over again. And that's why we got to get tenant harassment by landlords and building managers as a domestic dispute, because then you can get an order of protection without an arrest. But Judge Weisberg's court attorney contacted our lawyers, and the HP case is going back on trial. Well, they're calling us in for a hearing of some sort Wednesday, next week Wednesday on October 14th. So we, of course, are going to say, hey, respondents, where's your plan for how you're going to get us back into the room? And we're going to see what they say. They may file another 11th hour motion to dismiss, think maybe they can run the table on this. They've already put forth a response to everything, saying a whole bunch of lies, and I'll read those to you in some other, the next time I come around. Basically saying that it was the tenants who illegally chopped up these apartments and turned them in and installed walls and turned it into an SRO, and the answer is no. I think those walls were installed in the 1920s because you can peel back the wallpaper, all right? You can look at the molding and it matches. There are cuts that have been made to allow access to a fire escape from a kitchen that were made in the past 20 years, and that was the landlord who made those. There have been doors. I've got video of what they did to the second floor, removing walls and doors and stuff like that to turn that into an apartment. That building, I moved into the building and rented a single room. It's been a single room occupancy since before 1993. And when Efren Jarena bought that building as an SRO, he knew it was an SRO because he was collecting our rents from our rooms individually. Port Rich Realty knew this was an SRO, and they've been illegally collecting our rent since 1993. Those of us who's been there since 1993. So we're going to go in on Wednesday and see what Judge Weisberg says, and we're going to get those harassment issues put on the table, because getting us back in doesn't affect the person who's still living there and being harassed. All she's there for is for the harassment. And that's what this is about. So, thank you very much for listening to this. I got that read out on the record. I mean, annotated, of course. But thank you all who tuned in. Tom, Greg, there's a Craig and a Greg. Now, which of you is dating Marty McFly's sister? Jason, Mark, John, other John, and Christopher with an X, Christopheros. Thank you all for watching, and if you're watching this not live on replay or on YouTube, thank you again. Go to the YouTube channel 182 Saga. It's not in the URL yet because I don't have enough subscribers, so subscribe to the YouTube channel 182 Saga. Okay, watch the videos, like them, comment on them, and we do have this lawyer costs money, and we do have a little fundraiser going, and there's the URL down on the bottom of the screen. GoFundMe.com/182 Graham Saga. It's Graham Avenue, 182 Graham Avenue, so it's the saga of 182 Graham Avenue. GoFundMe.com/182 Graham Saga, and donate whatever amount you like to our legal action fund, and I'm going to send you one of my videos, either of the documentary of the Penzic War or the USA team at the World Championships, if you give me $20 or more. All right, thank you very much. Hang in there, everybody. Now remember, the numbers are going up here in New York City, so clean up, cover up, and call your loved ones. Because not everyone's getting out of here alive, folks. I love you all. Thank you very much. This is Captain Zorikh coming at you.